Welcome to our webinar this afternoon. I'm going to speak to you about how to document a parenting agreement and enforcing arrangements. My name's Susan Miranda. I've been practicing in family law for 15 years now, and I'm an associate at Michael Lynch Family Lawyers. This is just a little bit about our firm. We've been established for 20 years. We have 8 lawyers with over 100 years combined professional experience. We have private clients and we provide confidential and professional advice. We also produce regular articles and publications. Importantly for your clients, we offer a fixed cost initial consultation for $330, including GST. Next is just an overview about the topics I'll be covering this afternoon. What is a parenting order? How to document a parenting agreement? Schools, how do they fit into parenting disputes? Police involvement in parenting disputes? A little bit about contravention of orders. I'll be giving you some preemptive action tips for parents that they can take to assist in avoiding future disputes. And if you're able to stay for the full duration of the webinar this afternoon, you'll receive a CPD credit and a certificate of attendance. So when we look at family law matters, there are a number of terms that arise frequently. Pre-1996, the terms, as you can see, were guardianship, custody and access. These are the terms that people still use today often, but it's really not the correct way to refer to parenting arrangements. Post-1996, the terms were residence, contact and specific issues. But now the terms that we use are a lives with order, i.e. who does the child live with, and it can be an equal arrangement, or who does the child spend time with, that's instead of contact or access. Just briefly, you see there I've mentioned certificate of mediation. I refer to it as a Section 60I certificate. This is a certificate that parties will need if they want to make an application to court for parenting issues. They'll need to show that they have tried to reach agreement with the other parent, and they do this by using a family dispute resolution practitioner who can issue a Section 60I certificate. Of course, there are some exceptions in the cases of urgency. So what is a parenting order? A parenting order can deal with a whole host of issues. Probably the main one, though, is where a child will live and who they will spend time with. It can also deal with how a child will communicate with the other parent. For example, telephone communication, or will there be Skype time or FaceTime? And who has parental responsibility for a child? Parental responsibility is usually an example of this in an order might be that each of the parents have equal shared parental responsibility for the child, and for this purpose the parents be jointly responsible for making decisions about major long-term issues in respect of the child. And this can include, but not limited to, the child's future education, a child's health, changes to a child's living arrangements, which make it significantly more difficult for a child to spend time with either parent. A parenting order can also deal with a specific order about which school a child should attend and who can make the decision, and about a child travelling overseas. So parenting arrangements, if you have a client that has reached an agreement with the other parent, but they want to know how to document it, there are a number of ways. And I'll talk about verbal agreements, i.e. where there's no documentation in place, a parenting plan, and a consent order. So a verbal agreement, these can be a useful way for parents to continue to co-parent after separation, especially when parents can continue to discuss their children's needs and really put aside their own emotions around the separation. These parents are able to put the children's best interest first, and it allows for a lot of flexibility. It can be changed easily. Obviously, though, if it is just a verbal agreement that is in place, usually there's no evidence of the agreement, and there's nothing binding on either party. More often we'll see people putting into place a parenting plan. So care arrangements are put into a parenting plan. It's in writing, and both parents need to sign and date the parenting plan. However, there is no standard form that they can fill out. They can really just draft it themselves, or they can draft it with the help of a counsellor or mediator or solicitor. It is quite flexible, and because they can do it themselves, there is minimal cost. However, it's important to point out that a parenting plan is not binding on either parent. So if parents have agreed to a parenting plan and one person decides not to follow it, there's not a lot the other parent can do about it. They certainly can't enforce a parenting plan. What it does is it provides evidence of a parent's intention at the time of signing it. If the matter does end up in court, the parenting plan can be provided to the court as the evidence of the parent's intention, and the court can have regard to that parenting plan, but the judge is not bound to follow it. It is really just one piece of evidence that they'll consider. So if you have clients that think they might want something more formal in place and something that is binding on both parties, then they can do a consent order. And sorry, before I get to consent orders, I've just put here some suggested headings for a parenting plan. So this is if clients are doing it themselves and they're not sure what they need to cover. A parenting plan can cover major decisions. So how major decisions about a child's upbringing are going to be made. A child's living arrangements, who do they live with, who do they spend time with. If there needs to be a change in the future to the parenting plan, should there be some reviews, how often? Should it be a 6-monthly review or a 12-monthly review? And that'll often depend on the age of a child. If you have a parenting plan that's in place when a child's in preschool or in kindergarten, that might need to change when they get to school age. It can deal with communication, how often a child should telephone each parent. And also there can be a heading unresolved conflict, and a way that clients can deal with unresolved conflict would be to agree to attend a family dispute resolution centre at first instance. And a reminder, both parties should sign and date the parenting plan. So just moving on to consent orders then, what are they? They are negotiated agreements between the parents, and that is therefore similar to a parenting plan in that respect. Parents can negotiate by themselves or with the help of a solicitor. Once they have reached agreement, it does need to be formally documented, and that's done by preparing 2 documents. The documents are the consent order, which sets out the parenting arrangements the parties have agreed to, and another document called an application for consent orders. That application for consent orders sets out some background information that the registrar of the court will need in order to make a decision about whether the consent order they've been asked to make is in the best interest of the child. So those 2 documents get filed in the family court registry. A registrar will then consider those documents, and if they're happy with them, they'll seal it and issue it to the parties. It is then a court order, and it has the same weight as if the parents had been through the court system and a judge had made those orders. So what this means is that once an order is made, it can only be changed by further order of the court or by another consent order made between the parties. And it's in place until a child turns 18 years of age. So once a parenting order, that is an order made by the court or a consent order, is made, it does become binding and enforceable. So a party must do everything a parenting order says and can't be passive in complying with the order. Positive action must be taken to comply with the order, and that includes encouraging a child, even a teenage child, to comply with the order. For example, if the order states the children are to spend time with the other parent, for example, that the children spend time with the mother every alternative weekend from 9 a.m. Saturday till 5 p.m. Sunday, then the parent who the children live with must not only ensure that the children are available to attend that time with the other parent, they must also positively encourage them to go. Sometimes a parenting order might be framed in these terms: children shall spend time with the father as agreed between the parties, but failing agreement as set out below. So that does allow parties to still have some flexibility even if they have orders, so they can then decide between themselves, and it's only when they can't reach agreement that they then revert to the order. So next I'll take a look at schools and some topics that are important when it comes to schools and family law. What information do schools require? How does the school fit in when there are parenting arrangements or problems? And what if you have a client that wants to change their child's school? Information required by schools. It makes sense to make the child's school teacher aware of a separation. That teacher can then pay extra attention to the child and also recommend some guidance counselling or counselling through the school if required. It's my recommendation that parents don't change emergency contact details held by the school because of a separation. Now, what I mean there is that they ensure that both parents remain an emergency contact. Obviously, address details and phone numbers may need to be updated, but if there is some concerns or some severe domestic violence, then that won't apply, obviously. If parties have sealed consent orders, a copy should be provided to the school. Now, what I wanted to point out here is that parents need to be aware that if they are involved in court proceedings, or even if they've been in a court proceeding and it's been finalised, any family report that was prepared as part of the proceeding or affidavits filed in the family court or federal circuit court are confidential and should not be shown to any other person who is not a party to the proceedings, and that includes not showing anything to the school, except for a copy of the sealed order. So how does a child's school fit in if there are problems with parenting arrangements? In our experience, a school is usually reluctant to become involved in parenting disagreements over a child's living or spend time with arrangements. If you're involved in a court proceeding about a child, it can be helpful to issue a subpoena to the school for school records. The subpoena would usually capture school report cards, any notes that a teacher or principal may have made about incidents at the school, and also school attendance records. And this can be really helpful in family law parenting proceedings. Sometimes a teacher might be willing to go on affidavit to provide evidence for a court case about parenting matters, but this is a rare occasion, and usually the Department of Education would step in and put a stop to it. I did have cause in a matter a few years ago to have an interview with a teacher, and the teacher was willing to give an affidavit. There was an incident where the child was taken from the classroom by a parent without the other parent's consent or knowledge, and my client was very concerned about the child's welfare. It was important that we had evidence before the court about how that occurred, what happened, what did the parents say when they turned up to school, how did the child react, that type of thing. Just a note that a child's regular attendance at school is obviously extremely important, and often there is a lot of weight placed on a subpoenaed evidence about a child's attendance records at school, especially if they're consistently missing school while in one parent's care, or if they're consistently late. So what happens if you turn up to collect your child from school and the other parent has already taken the child without their consent or permission? Firstly, your client should try to contact the other parent to find out why, if they don't already know. Your client should try to speak with their child to ensure they're all right. Phone contact should always be allowed in almost all circumstances. So if you are seeing a client who is the one that has taken the child, you should really encourage them to allow that telephone time with the other parent. Obviously, parents need to be warned that they really shouldn't be involving children in adult issues, so any questioning of the child should be avoided. If your client's not able to contact the child or the other parent, they can ask the Queensland Police to do a welfare check. And obviously, if they're very concerned, they can also make a report to Child Safety Services, which is part of the Department of Communities, Child Safety and Disability Services. Just a reminder, if this was to happen to one of your clients, then they should obtain some legal advice about their options, and their options will depend on whether they have an agreement that's documented. If it's a parenting plan, it won't be able to be enforced, but if they have a consent order or a court order, it can be enforced, and that might mean going back to court and filing a contravention, which I'll talk about a little later. If there's nothing in place, they can make an application to court seeking orders about who a child is to live with and how the child's to spend time with the other parent. It's important to remind your clients that keeping a child away from school just so the other parent doesn't take them is usually not a good idea. Preemptive action can sometimes assist as well if your client is concerned or they have information that the other parent may try to collect a child from school without their knowledge or consent. They can put the school on notice by writing to them that they do not agree to that occurring and that they are to be contacted immediately should the parent attend the school. So what if a parent wants to change their child's school? What school a child attends is often a sticking point between parents after separation and can quickly lead to a tug-of-war match between parents. If you have a client that has a parenting order in place and there is an order for shared parental responsibility or equal shared parental responsibility, then no changes should be made to the school unless the parents both agree. But that's because the definition of major long-term issues, which education falls under, in Section 4 of the Family Law Act makes it clear that decisions regarding the education of a child should be made jointly by parents where there is an order for shared parental responsibility. Obviously, if your client has a court order about where the child is to attend school, then they should not be going against that court order. And a reminder that it's much better if parents can reach agreement themselves without having to resort to court action, remembering that an application to court can take many months to resolve, if not years. Also, give your clients a gentle reminder that the court be deciding the application based on the best interests of the child and not the best interests of the parent. Some examples of orders that can be included by your clients in parenting plans or that come up in consent orders and court orders about schooling, that as and from the school year in 2018, the children A and B will attend the X primary school or such other school as the parties agree upon in writing, and that each party keep the other informed of the children's progress at school, as well as all parent-teacher appointments, co-curricular activities involving the children so as to provide the other with the opportunity to attend, or the parties do all acts and things necessary to authorise the children's school to provide school notices, information, newsletters and school reports directly to each party. That last one is one that we see most commonly included in parenting orders. Therefore, it's not putting all of the weight on one person to do all the dissemination of information. It's really up to both parties then to make contact with the school. So next I was going to talk about children's wishes, and I have a polling question for everyone to have a go at. I'll give you some time to think about it, but the question I've got is, if you have a client that has had some consent orders in place for a number of years, maybe since the child was 6 or 7, but now their child has turned 13 and they've decided that they don't want to see the other parent, even though the court order provides for them to do so. Can that 13-year-old make up their own mind in these circumstances? A, true, or B, false? I'll just give you some time to answer that. Most people have answered now, and most people, 83%, have answered false and 17% true. This is a difficult question. Basically, if you have an order in place, as I said earlier, that order does stay in place until a child is 18 years of age. And a 13-year-old shouldn't really be making up their own mind. The parent whom they live with should be encouraging that child to spend time with the other parent. In saying that, children will often vote with their feet. But if they were to do so, the parent who they were living with could then be in breach of an order. That parent should really look at maybe making some variations to the order, whether it's by consent with the other person or maybe even having to make an application to court. And like I said, a child's wishes can have some weight in these decision-making processes, and the court will take them into account, but it is not the only evidence the court will take into account. Recently, I went to a seminar by David Hugel, who's the head of the Child Dispute Services at the Family Court and the Federal Circuit Court. His view was that once a child has a smartphone, then they're really at a stage where they're making their own decisions and their wishes will be taken into account. The Family Court stated in relevant case law about children's wishes is following quote, "As a matter of practical day-to-day experience, the problem in this area usually relates to the ascertainment of the wishes of the child and their interpretation and assessment in the face of conflicting evidence. Against that background, the court will attach varying degrees of weight to a child's stated wishes depending upon, amongst other factors, the strength and duration of their wishes, their basis for the wishes, the maturity of the child, including the degree of appreciation by the child of the factors involved in the issues before the court, and the longer-term implications. Ultimately, the overall welfare of the child is the determinant. If there's an older child involved, the court will almost always order a family report as a way to get the child's wishes before the court. Next, I was going to talk about police involvement in parenting disagreements. First of all, your clients really cannot rely on the Queensland Police to solve parenting disputes. The Family Law Act is Commonwealth legislation, and that really means that the state police are reluctant to become involved in parenting disputes. In the event of separated parents having a disagreement about who a child should live with or spend time with, if the disagreement was to escalate, they can, of course, telephone the police. They may find the police reluctant to become involved, and a police officer will not make a decision for the parents on where a child should live, and nor will they enforce an order of the court about parenting arrangements in most circumstances. Sometimes Queensland Police will do a welfare check. That is, if a parent is worried about the welfare of the child in the other parent's care, the police will go around to the house, visually sight the child to check they're okay, and then let the other parent know. But that's usually the only intervention they'll do. However, obviously, if there's some domestic violence, they will intervene in the usual manner. So what about the Federal Police? First of all, it's interesting to note that the Federal Police do have a presence in the Family Court and Federal Circuit Court precinct. I had a case many years ago where a Federal Police officer was present in the court whilst the case was being heard. Halfway through the matter, the father started making very threatening comments towards not only my client but the court, and the Federal Police officer stepped in. The Federal Police are also the ones that will action a recovery order when, if it's made by a court, and they're also the ones that action the family law watch list or breach of the family law watch list. So I'll talk about the family law watch list in a minute. Just talking about a recovery order and what they are. They can be sought without notice to the other parent in order to recover a child wrongfully retained by a parent. These are serious orders and the courts do not make them easily, so it's important that the person making the application has put all of the necessary evidence in their affidavit. Once a recovery order is made, it is sent by the court to the Federal Police to execute. Sometimes the Federal Police will ask the State Police to also action it. It might be necessary for you to speak to your clients about overseas travel. Once a parenting application has been filed with the court, even if no orders have yet been made, or while a parenting order is in force, it is a criminal offence to take a child who is the subject of that application or order outside of Australia, except with the written and properly witnessed consent of the other party to the proceedings, or order of the court permitting the travel. The maximum penalty for taking a child outside of Australia without that consent or order is 3 years imprisonment. The Australian Federal Police, like I said, they maintain the family law watch list. That is where if a parent is concerned that the other parent may try to take a child out of the country without their consent, the parent can place that child on the watch list. So if someone was to try to exit at any point around Australia with that child. When the child's passport is scanned, it immediately alerts the Australian Federal Police, and they will come running and stop the child from exiting the country. The Australian Federal Police have a very helpful website, and I've just got a link to it there, the Family Law Kit. If you do have a client in these circumstances, it's very helpful to have a look at their website. I'll just talk a little bit about contraventions. The contraventions by itself is a whole other seminar, so I'll just really skim the surface here today. If a parent has an order in place for parenting arrangements, whether it is by consent order or court order, and the other parent does not follow that order, it can be considered a contravention of the order. As I stated earlier, the police will not deal with it. The parent will need to bring an application for contravention of orders in the Federal Circuit Court. If you have a client who has these concerns or issues, it is best they seek legal advice before filing for a contravention to ensure they have the necessary evidence and to make sure that is the right action for them to take. So what can a contravention application achieve? The remedies are resumption of time, make-up time. So if a parent has missed some weekends, perhaps they might get extra time in the holidays. The court can vary the existing order if there's a reason why that existing order is not working for the parties and leading to contraventions. They can change the orders. The court can order a warning to the person who has been found to have contravened, and more seriously, they can issue a monetary fine or even imprisonment. So in summary, before commencing a contravention application, your client should carefully consider if the contravention is serious enough for the court to interfere, and getting legal advice can assist with that. Also, consideration whether the contravention application is the best way to remedy the problem. For example, an application to vary a parenting order might be a better option for them. So next, I'm just going to, I've really listed some tips and hints here about how clients can take some preemptive action to avoid future disputes. Personal counselling can assist. Obtaining legal advice, always obtain legal advice before you agree to or implement any plans or sign anything, even a parenting plan. Perhaps consider mediation instead of court proceedings. I've listed here, beware the use of social media. This is twofold. So this is not only making comments about your parenting dispute on social media, but also a reminder that the court really doesn't want to see a lot of sort of Facebook messages attached as evidence. I've often heard the judges of the Federal Circuit Court say this is not trial by Facebook. Perhaps you could tell your clients to consider the use of a communication book. So that's just any sort of notepad. It's helpful if the pages are numbered. They can then write notes in there about if the child's had any medication, or if the child's young, about how often they've slept, things like that. And that book travels with the child between the parents. Another good tip is for a client to keep a private diary of significant child matters. Now this is not to say that, and I'm not recommending that a parent should be emailing the other parent, pointing out all of the parenting flaws or problems that they've heard about whilst the child was with the other parent. Some people think this will help them in the future if they've got this email evidence of them really being a helicopter parent. Often that will show the opposite, and I discourage people from doing that. Perhaps parents could consider preparing a roster of the child's activities that both parents have access to, or consider colour coding a calendar for parents' days with the child. Now, there is a website that has made this sort of calendar coding and rostered activities a bit easier. It's www.ourchildren.com.au, but that does cost money for parents to access that. But maybe that might suit some people. This seems obvious, but returning a child's clothing at the end of time, it is something that my clients are constantly raising with me in parenting disputes, that they've bought new school uniforms or new clothing for the child. It's gone with the child to the other parent and hasn't been returned. Both parents should be informed and know about any doctor's appointments for the child. Obviously tell the other parent if you're running late for changeover, and tell the school, as I mentioned before, about a separation, and update details, but don't remove parents from emergency contact. Family Court has some helpful publications on parental conflicts. Sorry, it's a rather long link, but it is there. They point out in their fact sheet about different types of problematic parenting behaviours, things like asking children to carry hostile messages to the other parent, asking children intrusive questions about the other parent, which just creates a need for a child to try to hide information. And also, it also creates a need for children to hide positive feelings for the other parent. Also, it should be avoided demeaning or putting down the other parent in the presence of a child. Children should feel free to talk openly about their lives in both households, but not feel obliged to do so. They should feel safe when expressing their feelings regardless of which parent they are with. Also, just point out that parental attitudes and responsibility is important evidence if you do have a client in a court proceeding, because a court must consider the attitude to the child and to the responsibilities of parenthood demonstrated by each of the child's parents. And it's one that the court places a lot of reliance upon in making orders regarding children, because it demonstrates things like whether a parent is child-focused, the maturity of a parent, and the long-term parenting issues such as attitudes to schooling, childcare, television, diet, and other parenting issues. Now, if you or your staff want to know more, or you've got any specific topics relating to family law and you need some answers, please don't hesitate to contact us. We can even come to your firm and give a more in-depth presentation. Here's our contact details. Just a reminder that we do offer a fixed fee first consultation for $330, including GST. That first consultation will really spend as much time as we need to obtain all of the background information that we need in order to provide the client with their options and the consequences of each of those options. We'll often spend more than an hour as well. Just like to thank you all for attending today. If you've got any questions, my direct email is there. Please email me. And also just pointing out our feedback survey, that would be great if everyone could fill that out for us. Thank you and have a good afternoon.